Tactical Guy 1 here from the YouTube world, bringing you another video. I know people are going to complain and cry and moan and groan how this video is not picture perfect, it's too flashy, too grainy. But I say if it's not broke, why fix it? The main point I make my videos for is to help people understand certain rights that they may have, may not have, but stuff that I would do if I were in certain situations. And in this situation, People versus Garcia, it's a case that's interesting because it shows that you can be convicted of a crime even though you file proper motions that they should have honored and dismissed your case because you actually filed proper motions. But this case, People versus Garcia, proves that the courts are so corrupt that, at least the lower courts, of course, are so corrupt that they will find you guilty. Then you have to go and appeal to the higher court, and then they got to look at all the motions you filed or any arguments you made or your attorney made, or if your attorney filed any motions, and then they see if you were correct or if you were incorrect. And if you were correct, guess what? Case dismissed, let him go, he's free to go. And that's what happened in this case. But this case goes to show that the lower courts will still drag you through and hope that you go for a plea bargain, because then you really can't appeal that. Because a plea bargain is a contract. You're admitting to some sort of guilt even if you're innocent. So when you try to plea, don't do it. I wouldn't. Now, of course, I'm not an attorney and this is not legal advice. So please consult an attorney before you start doing anything that might get you in trouble. So, also, I wanted to say that make sure if you have an attorney, I would make sure that my attorney is filing as many motions as possible, or at least that apply to my case. I don't want him filing different things and trying to throw in the kitchen sink hoping something sticks, because it doesn't work that way. It just makes you or him look or her look like they don't know what they're doing, or it makes it look like you don't know what you're doing. So make sure you are familiar with the criminal procedures, and certain motions are supposed to be filed at certain times. And that's why you need to be familiar with that as well, because even if your attorney is or isn't, you still won't know if he or she is doing it the right way. So at some point we all have to have some kind of responsibility for our own lives, and we need to know laws that can affect us. Of course it's not fun, of course it takes time, but guess what? At the end of it all, you will have your freedom, and how much is that worth, right? So most of this stuff you can read for about an hour and a half. The criminal procedures in most states takes that long, if that. So just keep that in mind. Now, in this case, Mr. Luis Acevedo Garcia cited another case called Terry versus Ohio. Now, this guy was from California, People versus Garcia, California, and he cited Terry versus Ohio, which is or was in Ohio, but it was a Supreme Court case, so therefore now it applies to every state. So if you are any state, Terry versus Ohio applies to you, or actually to the officers. And the way it applies to them is that it allows the police to perform a pat-down search for weapons where there is a reason to believe that the person is armed and dangerous. So keep that in mind. If an officer looks at you and you're putting your hands in your pockets or in your sweatshirt, and he or she simply says, oh, I thought they were armed, or he was armed, or it was late at night, I don't know, so I had to hold them and do a pat-down search, which in other words just patting down the person from the outside to make sure that this person has no weapons on them. It could be needles, knives, clubs, batons, whatever, you name it. If it can be construed as a weapon, then they can do the pat-down. However, in this case, this Mr. Acevedo filed a motion to suppress because that was not the case. But even then the court said, nope, denied. Your motion to suppress is denied. Oh, you know what you're doing. You're an idiot. Just plea bargain, plea bargain. I'm assuming, of course, that they said plea bargain, but I'm pretty sure that's exactly what happened. And he said no, 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 and was convicted either way until he appealed. And then the Court of Appeals, or the appellate court, looked at it and said, oh, he was right. Guess what? Get out of jail free card. Here it is. But anyways, what happened was in June 5th, 2005, appellant was riding a bicycle without an operative headlamp. Officer Smith lawfully detained him for violating Vehicle Code Section 21201 Subdivision D. He asked the appellant for identification. Appellant, who spoke limited English, said that he had no identification. On direct examination, Officer Smith testified. Now keep in mind, folks, Terry versus Ohio applies to every state, and they can only pat you down if they believe you are armed and dangerous. So, question: what did you do next? Answer: I attempted to search his person for identification in order to issue him a citation for the vehicle code violation. Wrong answer. Question: and where did you start searching? Answer: I started to patrol down the exterior. Well, prior to that, when I grabbed him, he had pulled away from me and started saying probation in Spanish, which, excuse my accent, I don't have that good of a Spanish language accent, but it was probation, and I had to use minimal force by putting the subject's arm in a control hold. Of course. Question: okay, you indicated that you grabbed the defendant's arm. Why did you do that? Answer: in order to check his person for identification. Question: and you indicated that the defendant pulled away? Answer: yes. Question: what did you do next? Answer: I used minimal force by grabbing a hold of his arm and placed him in what's commonly referred to as a control hold just to gain control of him. Question: and what did you do next? Answer: he complied after I did that. He was placed in handcuff restraints for my safety just due to the fact that he started to pull away from me to avoid any further violent conflict with him. I don't believe that part, but question: were you able to then search the defendant? Answer: yes, I was. Question: what did you find? Answer: as I was searching him, I was doing a pat down on the exterior of his pants, and inside of his right front pant pocket, as I was patting him down with an open palm, I felt a bulge, and it appeared like it was a crystal grain type substance. Through my training and experience, I knew the substance to be crystal methamphetamine. Some training. Question: did you remove that particular bulge that you described? Well, where on the defendant did you feel this particular bulge? Answer: in the right front pocket. Question: and at some point did you retrieve that item? Answer: yes. Question: when you retrieved that item, what was it? Answer: it was a white crystal type substance, which again, through my training and experience, I believed it to be crystal methamphetamine. In the trial court, the sole prosecutorial justification for the seizure of the controlled substance was a pat-down search for identification. I'm going to post a link here, and you guys can read the rest for yourselves, but keep this in mind, folks. Cops cannot pat you down for your identification or anything except for weapons, if they believe you are armed and dangerous. So, thanks for watching. Hope you guys enjoyed it. And please share this with your friends and family members, because you just never know when they're going to encounter an officer who's going to want to do whatever he wants to do or whatever she wants to do. So, once again, folks, thanks for watching, and I hope you liked the video.